federal judge just did something unprecedented. Asset seizure, immediate enforcement. No appeal stays the order. Donald Trump's financial empire, the thing he's protected more fiercely than any classified document, is now under direct judicial control. This isn't a fine. This isn't a delay. This is the court saying, we're taking it now. And if you think this is just about real estate, you're missing what's really happening here. Let's be clear about what just occurred. Judge Arthur Engoron didn't wake up and decide to seize assets on a whim. This is the culmination of a civil fraud case that exposed systematic financial fraud spanning decades. We're talking about New York Attorney General Letitia James proving with bank statements, tax documents, financial disclosures that the Trump organization inflated asset values to defraud lenders and insurers. The ruling came down, $454 million in disgorgement and penalties. Trump was ordered to pay. He appealed. Standard move. But here's where it gets interesting. Normally, when you appeal a civil judgment, you post a bond. The bond stays enforcement while the appellate court reviews. It's procedural, it's routine. Every defendant with resources does this. Trump's legal team moved for exactly that, asked the court to stay enforcement pending appeal. The judge said no. Think about that for a second. A New York State Supreme Court judge looked at the financial records, looked at the pattern of conduct, looked at the risk of asset dissipation, and said, I don't trust you to preserve these assets. Enforcement begins immediately. That is extraordinary. From a prosecutor's perspective, that tells me the court sees flight risk, not necessarily Trump fleeing the country, but assets fleeing jurisdiction. Money moved offshore, properties transferred to shell companies, the kind of financial maneuvering that makes judgments uncollectible. The court isn't waiting to find out. Now, Trump's attorneys argued what every defense lawyer argues: irreparable harm, due process. The appeal has merit. They pointed to his supposed liquidity issues, claimed he can't post a bond that size without selling assets, which would cause irreparable damage. Here's what they're not telling you. That argument only works if the court believes you're operating in good faith. If you've spent years inflating values when it benefits you and deflating them when it doesn't, you've lost credibility. The judge knows what fraud looks like. He wrote a 92-page opinion detailing it. So when Trump's team says, we need time, we need relief, we can't comply, the court's response is, you created this problem. You don't get to use your own fraud as a shield. And that brings us to the seizure order itself. Judge Engoron authorized the Attorney General's office to begin identifying and freezing assets immediately. That means state authorities can move on properties, bank accounts, business interests, anything within New York's jurisdiction that satisfies the judgment. This isn't theoretical, this is enforcement. The New York AG's office has already filed notices with financial institutions. They've identified key properties: 40 Wall Street, Trump Tower, Seven Springs Estate, the Westchester Golf Course. These aren't just symbolic targets. These are high-value assets that can be liquidated or placed under receivership to satisfy the judgment. Pay attention to this next part. Receivership is the nuclear option in civil fraud cases. It means the court appoints an independent party to take control of the business, manage operations, and ensure assets aren't hidden or transferred. It strips the defendant of control over their own enterprise. The AG has asked for exactly that: a monitor with expansive powers, potentially a receiver if compliance isn't immediate. Trump's legal team is calling this politically motivated. They're calling it overreach. They're appealing to the First Department Appellate Division, arguing the trial court exceeded its authority. But here's the legal reality. New York's fraud statute, Executive Law 6312, gives the AG broad power to pursue businesses that engage in repeated fraudulent conduct. The statute doesn't require victim complaints. It doesn't require criminal intent. It requires proof of fraudulent business practices that harm the public interest. James proved that. The court agreed. The judgment stands. And the appellate court, they're not going to reverse findings of fact unless they're clearly erroneous. Engoron's opinion is exhaustive. He cited specific transactions, specific misrepresentations, specific calculations. That's not getting overturned on appeal. So what we're watching is the slow motion collapse of a legal strategy built on delay. Trump has always litigated by exhaustion, appeal everything, delay everything, outlast the other side. That works when you're dealing with private litigants who run out of money or patience. It doesn't work against the state. The New York AG's office has unlimited resources and a mandate to enforce the law. They don't settle. They don't get tired. They execute judgments. Here's what they're not telling you about this ruling. This isn't just about Trump. This is about whether court orders mean anything when you're wealthy and politically powerful. From a prosecutor's perspective, every fraud case hinges on one question: can we actually collect? You can win at trial. You can get a massive judgment. But if the defendant hides assets, moves money, declares bankruptcy, you've won nothing. The judgment becomes a piece of paper. That's why judges take asset preservation seriously in fraud cases, because fraudsters don't suddenly become honest after they lose. And Trump's financial history, it's a case study in asset protection strategies, multiple bankruptcies, complex corporate structures, properties held through LLCs, transferred between entities, shielded by layers of legal separation. Judge Engoron sees that. He's not waiting for assets to disappear while the appeal plays out. This is the court saying, we know what you do. We're not giving you the chance. Now contrast this with how federal prosecutors handle asset forfeiture in criminal cases. When DOJ brings a major fraud prosecution, Enron, WorldCom, Madoff, they don't wait until sentencing to freeze assets. They file for preliminary injunctions, restraining orders, asset freezes at the moment of indictment, sometimes before. Why? Because by the time you get to trial, the money's gone. The same principle applies here. The court is treating this civil judgment like a criminal forfeiture. Move fast, secure assets, prevent dissipation. And that should tell you how seriously the court views the underlying fraud. This isn't a business dispute. This isn't aggressive accounting. This is systematic deception that undermines the integrity of financial markets. When banks can't trust financial statements, when insurers can't rely on asset valuations, the entire system breaks down. That's why the court is acting with urgency. Let me walk you through what the evidence actually showed at trial. The Trump Organization maintained two sets of books, not literally, but functionally. When they needed financing, properties were valued at their highest possible number. When they filed taxes, the same properties were valued far lower. Take Trump Tower. Financial statements sent to Deutsche Bank valued Trump's penthouse at $327 million, claiming it was 30,000 square feet. The actual size, 10,996 square feet. That's triple the real square footage. That's not a mistake. That's not optimistic valuation. That's fabrication. Or look at Mar-a-Lago. Trump's financial statements valued it between $426 and $612 million based on the claim it could be sold as a private residence to the highest bidder. But here's the problem. Trump signed a deed restriction in 2002 limiting Mar-a-Lago's use to a social club. It cannot be sold as a private residence. The actual appraised value accounting for the deed restriction, around $75 million. That's an 800% inflation. The pattern repeats across the portfolio. Seven Springs Estate, valued at $291 million when conservation easements made development impossible. Aberdeen Golf Course in Scotland, valued at $435 million with no supporting appraisal. This wasn't aggressive marketing. This was systematic fraud submitted to banks under penalty of perjury, and Trump signed those statements every year. Personal guarantee. From a prosecutor's perspective, that's the case. You don't need to prove he filled out the forms himself. He signed them. He benefited from them. He's responsible. The defense tried to argue the banks didn't rely on the statements, claimed they did their own due diligence, weren't harmed. Judge Engoron destroyed that argument. The statute doesn't require victim harm. It requires fraudulent conduct. And even if it did, the banks absolutely relied on these statements. That's why they required them as a condition of lending. The idea that sophisticated banks don't rely on borrower-supplied financials is absurd. Of course they do. They verify what they can, but they can't verify everything. That's why fraudulent statements are illegal, because they corrupt the process. Now, Trump's team has one move left. the appeal. They're arguing the statute is unconstitutionally vague, that the penalties are excessive, that the judge was biased. None of that is going to work. The statute has been on the books for decades. It's been used hundreds of times. There's no vagueness problem. The penalties are calculated based on ill-gotten gains, money saved on interest, money obtained through fraud. That's standard disgorgement. The Eighth Amendment doesn't apply to civil penalties designed to prevent unjust enrichment. And judicial bias, you need actual evidence. The judge ruled against me is not evidence of bias. What Trump's lawyers are really arguing is our client is too important to be held accountable. That's not a legal argument. That's a political one, and courts don't care. So what happens now? If the appellate court doesn't stay enforcement, and I don't think they will, the New York AG begins liquidating assets. That could mean forcing sales of properties. It could mean placing businesses into receivership. It could mean garnishing revenue from Trump-branded properties until the judgment is satisfied. This is bigger than one case. This is about whether financial fraud has consequences when committed by politically powerful individuals. For years, Trump has operated in a space where rules didn't fully apply. Banks wanted his business. Accountants signed off on questionable valuations. Regulators looked the other way. That era is over. What this ruling establishes is a principle. Fraud is fraud, regardless of who commits it. And that has implications beyond Trump. Corporate executives, wealthy individuals, anyone who thinks they can manipulate financial disclosures without consequence. They're watching this case. If Trump's assets can be seized, if his empire can be dismantled through civil enforcement, then no one is beyond accountability. That's the message the court is sending. Now let's talk about the political dimension, because it's impossible to separate the legal from the political here. Trump and his allies are framing this as persecution. They're calling it election interference, a politically motivated attack designed to drain his resources and damage his campaign. Here's the prosecutorial response to that. The evidence doesn't care about politics. The fraudulent financial statements were submitted before Trump ran for president. The investigation began based on congressional testimony from Michael Cohen, corroborated by documents. The trial followed standard civil procedure. The judgment is based on findings of fact. None of that is political. That's just law enforcement. But here's where it gets complicated. The enforcement of this judgment is happening during a presidential election. Trump is the Republican frontrunner, and the seizure of his assets, the literal dismantling of his business empire, will dominate headlines. That creates an uncomfortable dynamic, not because the case is illegitimate, but because the timing is unavoidably political. And Trump will exploit that. He'll claim he's being targeted because he's winning. He'll fundraise off the asset seizures. He'll tell his supporters the system is rigged against him. Some of that will work politically. It might even energize his base. But here's what won't change. The legal judgment stands. The assets get seized. The accountability is real. And that's the rule of law functioning as it should, indifferent to political consequences, focused only on enforcing the law. This is what separates democracies from autocracies. In autocracies, powerful people are above the law. In democracies, the law applies equally. We're testing that principle right now. Let me leave you with this. We're watching a historic moment in American law and politics. A court has looked at decades of financial fraud, looked at the power and influence of the defendant, and said, the law still applies. That shouldn't be remarkable, but it is. Because for too long, we've normalized a system where consequences are optional for the wealthy and connected. This case is changing that, not through political rhetoric, but through evidence, trial, judgment, and enforcement. The assets will be seized. The judgment will be satisfied. The rule of law will be upheld. Stay informed. Pay attention. This story isn't over. More accountability, more truth, more coming.